Mr. Bowler.
May it please the court, good morning. This case is about a self-described pedophile's challenge to his detention as a sexually violent predator under Chapter 229A. In the district court, the state offered two different theories for the confinement of Mr. Ruthers. The first is present confinement, 229A4 sub 1. The second theory is a recent overt act, 229A4 1 sub 2. These two different paths were both proven in this case beyond a reasonable doubt. I'm going to talk about present confinement first, because I think this issue, this prong of the analysis, is really straightforward statutory application. And I say application because it's not construction. This is the issue where the plain language just controls the resolution. Subsection G, under the definition of what a sexually violent offense is, permits the state to prove sexual motivation either at the time of sentencing or subsequently during proceedings under this chapter, and that's referring to 229A. What the state did here is exactly what the statute contemplates. At the bench trial for the 229A action, the state proved beyond a reasonable doubt that at the time the state filed its petition, Mr. Ruthers, the respondent, was confined for a sexually violent offense, here a sexually motivated assault. The district court made appropriate fact findings. There was evidence from the victim in the case, his CPC interview, his prior depositions, that established that the respondent, Mr. Ruthers, humped and performed other sexual...
Does it make a difference that he was confined only because he couldn't make bail?
I have two different responses to that. First, that is not the issue presented by the respondent in this case. I understand the Court of Appeals seems to have created that issue, but it wasn't briefed by the parties. That's not in front of the court. But even if it was, it doesn't make a difference. This is straightforward statutory application because the only question is whether the respondent was confined, presently confined, for a sexually violent offense.
But if you can't make bail, you're not really confined for the act that you allegedly did. You're confined because you're a flight risk, or you may not appear to trial. I mean, it's a different confinement pre-conviction.
And I think the premise that underlies your question is that if we assume your point is correct, you would have to believe that the respondent was not confined for that sexually violent offense. But in order to determine if it is a sexually violent offense, we can look to subsequent proceedings. That's what subsection G says. And this court addressed a version of that in Willis.
And if we agree with that, the question is, at the time he was he confined because of the act he did, or because the court felt he was such a flight risk, or he would not appear at trial, that they confined him to make sure he appeared for trial? I mean, I think there's a distinction there that you can't ignore.
I understand the court's question. I think Willis takes care of, or at least resolves, the issue presented. In Willis, the defendant had his jury trial. He had the jury return a verdict, but there was no judgment in that case. There was no adjudication. He was awaiting sentencing. And this court held that there does not have to be an adjudication for a sexually violent offense at the time. The language the court uses is that we look at what the basis for the sheriff's custody of the respondent would be. In both Willis and in this case, the basis for the sheriff's custody was the commission of a sexually violent offense. There it was based on what happened following the verdict, and here it's based on what was ultimately a guilty plea. Even if we accept the court's premise that there's some kind of distinction that can be drawn there, that would be cured by the guilty plea for time served. That's an admission that he was serving time during that previous year that he was detained in the county jail for an offense that the state was able to subsequently prove was a sexually violent offense. That's why subsection G allows the state to prove that either during the criminal proceedings or subsequently during proceedings under this chapter.
Let me tell you what bothers me about the case. I see your reading of the statute, and it seems to me on its face pretty straightforward. And I don't know where this takes me, but it does bother me somewhat. So you had this plea agreement to the lesser offense that Ruthers signed, and then the ink is just dry on the plea agreement, and they serve him with the petition to confine him as an SVP. And it does strike me that this was sort of a strategy of the state instead of trying to get a conviction on the higher offense that clearly would have been, as a matter of law, a sexually violent offense. They did something that was, a little bit, I don't know, kind of. I assume they didn't disclose that plan to the defendant, and it seems a little bit sneaky if that's the case. That's all.
But, Your Honor, they did disclose it to the defendant. He was served with the 229A petition before he pled guilty in the district court.
He had signed the agreement already, correct?
The record's unclear on that point, and in any event, until that plea agreement is filed, that's what we're concerned about. When is it of record that he enters the plea? He did not enter a plea until the state had already served him with the 229A petition. And there's some discussion in the record that there were conversations between the public defender that was representing Mr. Ruthers at the time, and this is in the criminal case I'm talking about. And they actually called the special defense unit. They talked to Mr. Adams to make sure that everyone understood the nature of the deal that they were making.
Well, the record indicates to me, and maybe I'm wrong, tell me, that he signed the agreement on the 16th. They filed the SVP at 1:10 on the 19th, and the plea wasn't filed until 2:57 on the 19th. So the SVP was entered, the petition, before even the plea was filed.
Yes, the 229A petition was filed before the
And the
defendant
court
pled
didn't
guilty.
accept it till 3:50. So until 3:50, he wasn't convicted, because a plea or filing of the plea is nothing till the court accepts it.
I completely agree. That's why there was nothing underhanded by the state in this case. The defendant or the respondent was personally served with that 229A petition before the written guilty plea was presented to the judge and accepted. And let me just suggest that if we are concerned about what happened in that course, if we're a little concerned about maybe the performance of the defendant's criminal trial lawyer, that's not the issue presented here. That issue was finally resolved in an unpublished Court of Appeals decision, Ruthers v. State, in 2018. In that case, this court denied the application for further review, so that resolution of that issue is final and binding. And in that case, what the court found, the Court of Appeals and the district court, was that the respondent had really been the one that engaged in misconduct. They say he attempted to perpetrate a fraud upon the court or commit a fraud upon the court. But that issue is not in front of us today. All we're concerned about is whether under subsection G, the respondent was presently confined for a sexually violent offense. And that subsection tells us that we can prove that either in the criminal proceedings or subsequently during the 229A action.
I know let me interrupt for a moment. You're talking about prior confinement. There's two different issues, and I know you'll get to the other one. But I just want to ask you, if you had to only pick one, if you weren't allowed to do the shotgun approach and attack both, which avenue do you think is the strongest issue for the state?
Present confinement is the strongest because it's a straightforward, clear application of plain statutory text. As I mentioned, there is no construction involved here. It's a straightforward application, and the only question is whether the respondent was presently confined at the time that petition was filed for a sexually violent offense. We look at subsection G. How do you determine if it's sexually violent? Either in the criminal proceedings or in the 229A proceedings. And here the state elected to go in the 229A proceedings and prove that that offense was sexually motivated beyond a reasonable doubt. And that's what the district court found.
Is 3 years too far back to be a recent overt act?
It's not. Recent overt act doesn't even have a temporal component in how that is defined in the statute. The statute doesn't include anything about timing or how far back anything in particular can go in order to be a recent overt act.
Which would be too far.
This court in Moore said that 13 years wasn't too far in interpreting Chapter 229. Obviously, there's a little bit of difference between them, but the concept is the same. The reason that recent overt act was included in 229A was a consequence of this court's case law and the case law in other states that says that we need an overt act that reasonably predicts current dangerousness. Is 3 years too far back, Justice Waterman? No, not on the facts of this case. What we know is that particularly with child sex abuse victims, delayed disclosure is the norm rather than the exception. The reason that there was such a big delay in this case isn't because of anything the state did. The police weren't just sitting on their hands for years.
But if you look at all the facts of the case, the alleged recent overt act happened in, I think, October or November of 2007. He wasn't arrested until 2010, wasn't it? September 2010. There's nothing between the alleged act that got him arrested here and those 3 years. I mean, wouldn't you think if it's predictive, it should have happened, and something else should have happened in those 3 years?
No, in all likelihood, something else did happen during those 3 years. The overwhelming majority of sex offenses are undetected. Do we have an arrest that he perpetrated on another child during that window? No, but we wouldn't expect that given the nature of these acts. Our inquiry is whether or not that act is predictive of his current dangerousness, and we have to
That's
evaluate.
not what the statute says. I mean, recent, I mean, you're basically saying, and correct me if I'm wrong, but you're saying that recent doesn't have a time component. Now, I may buy half your argument, and that is to say that it's not, 5 years in all cases, Iron Curtain. I mean, they didn't do that either, right? So, I mean, the fact that the legislature used the term recent overt act strikes me as meaning there's some play in the joints because they didn't have a particular time. But having said that, the notion of a recent act being 2 decades old, for example, strikes me as a challenging proposition.
Let me break out a couple different pieces of that and try to address them. The first is whether or not the legislature included the word recent and tried to give some meaning behind it. The answer to that is clearly no, because if we look at the definition of a recent overt act, it's any act that has either caused harm of a sexually violent nature or creates a reasonable apprehension of such harm.
Yeah, but it still has to be recent. I mean, you don't write the term recent out. Now, that's arguably fairly ambiguous. I don't know exactly what it means.
The legislature, this court has said many times, is its own lexicographer. If the legislature had included or intended for recent to have a particular meaning, it would have given it one. Instead, there is no temporal component to the definition. But to address the concern that I think Your Honor has, there is some due process concern in every SVP case. We know this going back to Guerin from this court and Kansas v. Hendricks from the U.S. Supreme Court. The nature of that due process inquiry is that we are not using acts that are too stale in time to serve as a valid predictor of current dangerousness. That's why if a recent has a definition, as it's used by the legislature in the statute, it's not some fixed date or chronological component. The inquiry is whether or not the act at issue is reasonably predictive of current dangerousness.
But doesn't that kind of, as Justice Appel's pointing out, there is the word recent, and doesn't that approach just kind of read recent out of it? Because you're going to have to prove current dangerous anyway as another element of the case in order to confine the individual. So I guess why don't we just use kind of a reasonableness or a common sense approach to the word recent?
That door is certainly open to the court. You see some of that kind of analysis in the Washington cases. It's not exactly as Your Honor's question asked me, but the inquiry is really a flexible one. It's whether or not it is too stale is the language they use. And that's why I suggest it's not just is it reasonably recent. The inquiry is whether or not it's still a valid predictor of current dangerousness. And I want to analogize a little bit to Moore, which is a decision of this court. The overt act in that case was firing a gun 13 years before the respondent in that case was confined. And the context of that case is that the respondent was schizophrenic. At some point, he went off his medication, began acting more erratic, and the court had to look for a recent overt act that justified the confinement. Shooting that gun 13 years prior was reasonably predictive of current dangerousness when the respondent in that case went off of his medication. The record in this case establishes that pedophilia, which is the abnormality that the respondent was diagnosed with, is a lifelong condition. So we're looking for something that informs our analysis of the respondent's current dangerousness. The overt act about 3.5 years before is reasonably predictive because it shows that even after the respondent was released from prison, even after he was incarcerated, arguably had gone to some kind of sex offender treatment that he later refused or left, even after all of that, the respondent continued his long, really lifetime pattern of abusing boys in the ages between 7 and 15. He did exactly what he had always done because he is and continues to be presently dangerous and subject to confinement under Chapter 229A.
Mr. Buller, thank you. Mr. Adams.
May it please the court, counsel. The Court of Appeals got it right on the issue of presently confined. Mr. Ruthers was charged with a sexually violent offense. He was awaiting trial. It had not been determined in any fact or fashion that he had done anything wrong while he waited for his trial. He was preparing to defend to go to trial. He had not been found guilty of anything. As the Court of Appeals found, the only reason that he was in jail is because he couldn't make bond or chose not to make bond. He had not been found guilty of doing anything wrong with respect to that case. Now, counsel pointed out the Willis case, and I have a soft spot for Willis because I'm the one that argued that.
Just before you move on, does the statute require that he be found guilty?
It does not specifically, Your Honor, but if you look at the whole scheme, Iowa Code Chapter 229A.71, when you're talking about somebody who was found not guilty by reason of insanity or somebody found not competent to stand trial, the court must first hold a hearing to determine if the person did the act charged, if the person did something sexually wrong. And then you move on in subparagraph 2 to having the SVP trial. So it doesn't, but if you read the statute continuously, as this court has many times said, we try to read things in harmony, it does say that. There has to be a finding that the person did something wrong.
So help us out on Willis, because, which you're, I think, eager to talk about, because it does seem that says you don't have to yet have been convicted or sentenced
That
to
is
the
very true,
offense.
Your Honor. I argued the Willis case. I did the brief. I argued it to this court. And the comment was that the ruling that I was reading things in a hyper-technical fashion by requiring a conviction, an actual judgment of conviction to be pronounced. And I understand now why that was said. And I understand the court's ruling compared to this case especially. In Willis had been found guilty by a trial jury of committing the act charged. It wasn't that he was waiting in jail for trial. The trial jury found him guilty. And again, that's an adjudication with due process where the person did the act charged, did something sexually wrong. And the mere failure at that time of pronouncing judgment and sentence doesn't change the fact that he did something sexually wrong. And I think that's the distinction in this case.
But if you look at the definitional sections, the statute says, if it appears that a person presently confined may be a sexual violent predator, okay?
Yes.
Now, the definition of sexual violent predator under 229A.212, sexual violent predator means a person who has been convicted of or charged with a sexual violent offense.
Yes.
Doesn't have to be convicted or charged. Now, this guy's confined because he can't make bail, and he's charged with a sexually violent offense, because I think, I sort of agree with the state that you can prove it at the later hearing. Why doesn't that meet the definition under 229A.4.1?
This court, Your Honor, in re the detention of Geltz, at footnote 1, talks about this very situation. The charged language is only where there's been a finding of not competent to stand trial or not guilty by reason of insanity. And it was addressed in Geltz in footnote 1. So the fact that Mr. Ruthers was merely accused, does not win the day, as the Court of Appeals found.
What about his guilty plea to the lesser offense? Does that close the gap?
No, it doesn't, Your Honor. And Justice Mansfield talked about sneakiness. There was a level of chicanery in this case, and arguably on both sides, Mr. Ruthers' side and certainly the state. This was a Class A sex offense with life in prison without parole. When Ruthers and his defense team prepared to defend this case, somehow or another the state realized they couldn't prove their case. So they made him this sweetheart deal for a serious misdemeanor, 1 year in jail with credit for time served, get out and go back to West Virginia where you came from, and he pled guilty to that. Now, when I say chicanery on both sides, or skullduggery, or whatever word you want to use, Ruthers pled guilty to assaulting this young boy's mother. And I wasn't there, I don't know what he did to earn those charges. But he pled guilty to assaulting the boy's mother. He always denied assaulting the boy in any fashion. Under Stenzel, what is important is what the man has pled guilty, or the defendant has pled guilty to, or what he has been found guilty of following a trial with all the due process rights. Ruthers pled guilty to a non-sexual assault. He pled guilty to assaulting the woman. Now, as we know from the record, when everybody realized what had happened with this victim issue, the district court had held another hearing, and she went back into the minutes of testimony, as the plea agreement empowered her to do, and she found a factual basis. She found a factual basis, a very specific factual basis, and the trial court quoted the minutes of testimony in the criminal case. If you look at the minutes of testimony, the first line is, Ruthers humped the boy. And then it says, Ruthers threw the boy on the bed, he hit his head, causing a bump. Then the last sentence was, Ruthers continued to hump the boy. The district court, when she found the factual basis, she excised that first sentence and excised the second sentence. So what he pled to was not a sexual offense. What he was found guilty of the court for doing was not a sexual offense. And the issue of sexually motivated was raised to the district court several times. And the district court declined to make Mr. Ruthers register on the sex offender registry. The state didn't even ask for that to be one of his punishments. I mean, here, this law, 229A, is for the worst of the worst. These people are so dangerous that they can't be trusted to be outside in the community. And that's what essentially this court said in the Weigel case. They can't be trusted outside in the community because they're going to commit an offense. Yet the state gives this guy a sweetheart deal and doesn't even ask that he be put on the sex offender registry.
I want to ask you about that sweetheart deal. I haven't read every piece of the record, and I'm wondering, I'm assuming you have. Does the record indicate any understanding, conversation, or agreement about the potential impact of 229A? Because the state was given up a Class A felony, certainly. Everyone must have in the room been aware that it was a sexually violent offense at that original charging. So was there any discussion that this could come into play down the road in a 229A?
Not on the record, no, there wasn't, Your Honor. The only thing that even comes close is Ruthers hand wrote on his written guilty plea that the charge of sexual abuse in the second degree would be dismissed with prejudice. He wrote that before it was tendered to the district court. The district court knew all about this. There was motions in limine filed in this case. There was rulings on the motion in limine. It was following a motion in limine ruling that the state decided that perhaps their chances of proving this case in an SVP context was easier. And I say easier because if you go to the Swanson case where you talk about recent overt act, it makes sense that the person's whole history comes into play to see whether this particular instance.
I mean, what's so wrong with that necessarily?
Nothing, Your Honor.
It should be easier to prove an SVP case because it's, even though there's a reasonable doubt burden, it's a civil case, and it's a prospect that the defendant can get out, which there wouldn't be with a life sentence, right?
With a life sentence, there would be no possibility that he could get out. With a civil commitment, depending on how the individual performs, he may not get out either. There are people up there that will never get out. And whether it should be easier or not, there are standards of proof, so I would say they should be equally as easy. I guess, if when Ruthers was first apprehended or detained, if the state would have said, you're a sexually violent predator, we're going that way, they could have proceeded. What they chose to do is they chose to go the criminal route.
The Court of Appeals analysis, because the majority there thought 3 years would have been too stale to be a recent act, and 3 years had elapsed. So under the Court of Appeals analysis, that really wasn't an option, right?
Right.
Mr. Adams, before you answer that question, could you just pull the microphone a little closer to you? There you go.
I will.
Thank you.
I get the echo effect, and it's distracting to me. I apologize. Your Honor, what I was talking about is why it would be easier to prove in a sexual predator case, because you get all this bad acts evidence from before. And if you'd like, I can move on to recent overt act. You asked the question, how long is too long? Or where do we draw the line? And I don't think that is reasonable. I think it has to be recent, and I agree with counsel to a fair extent that it has to be proof, or it has to be reflective of the person's current status. And depending on the facts of the case, that could be a long time, or it could be a very short time, depending on the facts of the case. Now, counsel has quoted a couple cases, or one in particular, the Moore case. The Moore case, this individual respondent, he shot a gun 13 years prior. What the court found to be the recent overt act was his reflection 13 years later on what he had done. He didn't think he had done anything wrong 13 years prior. It wasn't the act 13 years that was the recent overt act. It was the way he currently thought about it.
Okay, so why is 3 years too long in this particular case?
And also the cases cited by the Court of Appeals, Your Honor, those were people that were continuously confined after the so-called recent overt act, not like Mr. Ruthers. The research in this area, sexually violent predators, you've all heard of the Static 99R. It was created by Carl Hansen in Canada. The majority of the research comes from Canada. Dr. Hansen reports in peer-reviewed research that a sex offender released from prison is most likely to reoffend shortly after release, within the first 3 to 4 years. Dr. Hansen also writes, and has written on at least 2 occasions, that if the person is released and goes for 5 years without committing a sexually violent offense or a sex offense, that his risk is cut in half. Because again, the majority of the people reoffend early on following release. In this particular case, and counsel talked about, we don't know what Ruthers did in that time. He probably did this. There's no evidence in the record of what Ruthers did during that time between this so-called recent overt act and when he was ultimately apprehended 3, almost 4 years later. If there would have been proof, it would have been a different story. But to comment on what he did or didn't do is merely speculation. And I think that if he is so dangerous that he fits within this law as one of the worst, that can't breathe a breath of fresh air without a fear that he's going to reoffend, there should have been proof that he did act that way during that 3 to 4 year period.
Let me ask you a question about that. Do you think it's possible under a scenario which we have today that perhaps the record could have been such that that your client more or less would have agreed that there would be that consideration of a 229A down the road? In other words, do you think some of these magic words could have been the terms of the plea at the time it was taken, such that the passage of time may not be as arguable as it is today? In other words, would your client, could you envision a situation where a record could be made that this act, even though it's been amended down substantially, was a sexually violent act, and have your client stipulate to that?
I suppose under this fact scenario, that arrangement could have been made. It could have been a bargained for deal. However, in this particular case, Mr. Ruthers adamantly denied doing anything to the boy. What the district court ultimately found as a factual basis about throwing the boy on the bed, the boy's discovery deposition transcript said that didn't happen. And that's what led to Mr. Ruthers pleading guilty to striking the adult female, because he couldn't plead guilty to something that the boy said didn't happen. So I think, again, a recent overt act has to be recent. It can't be stale. It has to be relevant to the consideration of what this individual's status is at the time he's under examination in the SVP case, or at the time the case is filed against him. In this case, the state filed under the presently confined issue, and it was several weeks later before they amended the petition to assert a recent overt act. And again, I don't think, given the research and the record in this case, that his act was sufficiently recent and not stale, as the Court of Appeals found. So I'm out of time. I'm asking the court to affirm the Court of Appeals. Thank you very much.
Mr. Adams, thank you as well. Mr. Buller.
I'm obviously significantly shorter than Mr. Adams. I want to talk a little bit about what we do with the Moore case. Mr. Adams has suggested that the recent overt act there was less the firing of the gun 13 years prior than it was recent reflection by the respondent there that he hadn't done anything wrong. If that is the test, then this case is a slam dunk for a recent overt act, because here we know that Mr. Ruthers doesn't think he did anything wrong when he molested numerous 7 to 15-year-old boys. He told Anna Salter that he has at least 4 or 5 victims. He told her that they enjoyed it when he molested them. When he spoke with the police, he described himself as a pedophile. He said it was a lifestyle. He says he likes to have relationships with kids who are 9, 10, and 11 years old. If the analysis we are concerned with is whether presently the respondent fails to understand the danger and the wrongness of his actions, then there is no question that Ruthers should be confined under the recent overt act analysis in the second part of 229A sub 4.
I haven't made myself very clear on that last question, but I want to get back to it with you. Based on this set of circumstances, couldn't the state have done a better job? I mean, if you've got a Class A and you're negotiating with a defendant and he's going to go down to a significantly lesser charge, isn't that the time you make a doggone good record about what you're alleging now?
Yes, part of the difficulty is I'm often on the back end, and it's difficult to Monday morning quarterback what happened in the trial court. One of the reasons that I think the state did file this 229A petition before the written guilty plea was filed of record is exactly the concern that you identify, to make sure that these ducks are in a row. The respondent knows what's coming. He's been personally served with that 229A petition in the county jail before the guilty plea is filed of record. There's no question he knew what was coming. even though under the Court of Appeals case law, 229A is a collateral consequence. There's no requirement he be notified of it. But the state went ahead and made sure that that petition.
And what is the record? Did his defense lawyer know? And I'm not, by the way, I'm not accusing anybody of being anything. I'm just trying to understand the facts. Did the defense lawyer know?
Yes, and the point I really want to make about all this factual discussion, I agree that the record's not clear. It's murky is perhaps a generous term for the state of the record, but none of that's in front of the court. That was all finally resolved in the post-conviction appeal from the Court of Appeals. So I think we're bound by those fact findings. And what the Court of Appeals found when they affirmed the post-conviction district court was that whether or not this was a sexual offense for purposes of 229A, not a term that was bargained for. It was the equivalent of open sentencing. It could be proven later or it could not be proven later. And there's no guarantee 229A goes forward. A prosecutor can't just decide to file a 229A petition. There's a lengthy process in the statute. It involves a prosecutor's review committee and expert analysis. There's no guarantee that even if a prosecutor wants to file a 229A, they will be able to. So there is certainly evidence that the lawyers, the respondent, the judge, because it was the same judge in the 229A probable cause finding as the plea, everybody knew what was going on. There's no real question about that. What I want to conclude talking about is really the language of Willis, which I think answers our present confinement question. There, this court said that there does not need to be an adjudication, that's the language the court used, in order to rely on the present confinement alternative. Mr. Adams' argument is there was an adjudication because there was a guilty verdict, but that's just not true. In a criminal case, the judgment is the sentencing order. At the point a guilty verdict comes back, there can be a motion for a new trial. The judge could set aside the verdict. Really, a lot could happen before that verdict is entered of record. Juries on their own don't adjudicate a claim until it's finally resolved. That's a judgment that includes a sentencing order in a criminal case. Here we're in substantially the same position as Willis. There's no adjudication, so we look at what was the basis for the sheriff's custody of the respondent. The basis for that custody was a sexually violent offense. Whether we look at the fact it was an enhanced sex second, which is a per se sexually violent offense, or if we look at alternative G, which allows the state to prove a sexual motivation for any offense, whether it's theft, assault, or anything else. No matter which analysis we conduct, the respondent was presently confined for a sexually violent offense at the time the 229A petition was served. I would ask this court to vacate the Court of Appeals decision and affirm the respondent's confinement as a sexually violent predator.
Mr. Buller, thank you. Mr. Adams, thank you again. Case of in re the detention of Ruthers is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.